SJC-11946, Commonwealth v. Brandon Mattier.
Thank you. Very briefly, Your Honors. If Mr. Mattier's case is not one where a stay is warranted, it is unclear to me where those cases are. As Your Honors are aware, there's two main considerations for stays: the likelihood of success on the merits and a security risk. With respect to the first one, while there are inconsistencies in the case law about whether it's a reasonable possibility or a reasonable probability of a success, he met his burden either way, and this court granted direct, which demonstrates he had an issue worthy of appellate review. And with respect to being a security risk, this was Mr. Mattier's first offense. He had no record. He was out on bail pending trial. These were nonviolent offenses. He had strong community contacts, and so we believe it was an abuse of discretion not to grant his motion for stay pending this appeal, and that this is just not how it should have been for him.
So in the absence of a security risk, whenever we take cert on a case, that's enough to guarantee that you should be released pending the resolution of the appeal?
Not guarantee, but but I think it's a strong. I mean, the question is there an issue worthy of presentation? And that's a strong.
Not one that will necessarily result in reversal of all the charges?
Right, well.
Because here on the identity fraud, he's not doing time on the identity fraud. He's doing time on the conspiracy charge. And the only way you get rid of the conspiracy charge is if you get rid of the identity fraud charge, which gets rid of the motion to suppress.
Exactly,
and then
which affects directly the conspiracy.
So it's kind of a journey.
It's a lot of steps, but steps which he.
So I guess my question is the success on the merits. What does that really mean in evaluating the likelihood of success on the merits? You getting, even if you win on the identity fraud issue, you may not win on the motion to suppress issue.
I think you're right. That would have to be the merits of the one that's holding you in.
The merits of the one that's holding you in.
But I think that.
And how likely does the likelihood have to be?
I think.
Or is it just an issue that is not going to get you laughed out of court?
Well, the standard, again, it's inconsistent in the case law, but it appears to be reasonable possibility of success. And so that's what the standard is.
So in this case, just remind me, was the motion filed, a motion filed first with Judge Locke?
Yes.
Who denied it?
Yes.
And does the fact of the successive layers here, well, I guess it's two, does that matter at all? In your view, that Judge Locke denied it, and I don't know what, I haven't looked at this record. I don't know what he said, but let's say hypothetically, he's got a concern about sticking around.
So the record is basically that he just denied it. There was no explanation. But I think that once direct is granted, that specifically, so we don't actually know why it was denied. But I think once direct is granted, that specifically gives this court really, I know that it's in discretion whether you review, but it's really in a different posture once this court says, well, there's something to look at here. Because he was out pending trial. He showed up for all of his court dates. But
are we looking at an abuse of discretion by the single justice?
Yes. Okay. Thank you.
Thank you. The case law is clear that a single justice can elect to just review a lower court's denial of a stay of execution of sentence based on abuse of discretion. So here, the single justice had enough to conclude that there was no abuse of discretion. I'll bypass the issue of likelihood of success on appeal and the merits because we've discussed that. But in addition to that, the procedural demonstration was not sufficient by the defense. So for example, below, they just filed a bare bones motion. They didn't say what issues they intended to raise on appeal. So that would make it hard for a judge to conclude that, in fact, they have a substantial likelihood of success on appeal. And then before the single justice, they didn't provide as much as they could have. So, for example, there was no affidavit from the person you'd expect to see one from, the defendant. In addition to that, the single justice would have been and the trial judge would have been within their discretion in finding that there are potential security risks.
What would those be?
Those would be the fact that it would be disruptive to his rehabilitation efforts.
How is that? I mean, you know, how should he be? I mean, that does strike me as a bizarre argument, to be saying that he should be punished for engaging in rehabilitation efforts by not being able to get out on bail.
Not punishing him, no. Just,
But that's the effect.
but it would just, the judge is,
So he should give up, if he gave up on his rehabilitation efforts while he was incarcerated, then he should be more eligible?
no, it's just that the security issue is looking at the public. It's not looking at the defendant. So that's,
So
look,
how does that affect the public?
if it would disrupt rehabilitation efforts, if he would be released without all the things that the DOC normally does before it releases someone, a judge could find in his discretion that raises
That is a
security
really
concerns.
hard argument for you to be making.
Well, we'd say that that's within the judge's discretion. It wouldn't be an abuse of discretion if a judge were to find that.
Does security risk include risk of flight?
Yes, that's one of the factors. I'm sorry, we're not arguing that there was a demonstration of risk of flight here, but that is a factor that can be taken into account. But the thing is, if the defendant wanted to show otherwise, perhaps the best way to do that would have been to file an affidavit, would have been to make some kind of a showing. Instead, there wasn't any submission in support of what is a request for a very significant form of relief, because it's not presumed that people are released pending appeal.
Okay,
Thank you.
All right.